Good morning, my good friend Samson, and good morning to your cherished listeners and viewers.
Right. We acknowledge the fact that you've had to move out of an important session to be part of this discussion. So let's make it quick. You have given responses that expose, if you like, the double standards as far as the two parties are concerned in seeking to raise and pontificate. But let's start with this from this premise. Okudzeto is seeking to introduce a bill that will stop public officials from acquiring state property. You subscribe to that?
Well, first of all, as I say, thank you for having me. And I believe that when the Honorable Ablakwa presents such a bill, if he's able to do that within this meeting of Parliament, I believe that the matter will be subjected to scrutiny. But the general principle of conflict of interest and the very fine line which exists when it comes to conflict of interest relating to public officials and state properties, that for me is a matter that we all have to be mindful of. I mean, there's absolutely no two ways about that. To that extent, I believe that if we define the rules clearly, that will go a long way to help.
Okay.
But on the broader issue of the management and utilization of our land and natural resources.
Yes, respectfully, before you get there, I want to get a clearer answer from you. In principle, will you in Parliament, as the majority, on your part at least, support a bill to prohibit, outright prohibition of public officials acquiring state property?
Well, something, I think you should be fair to me. I will not be able to speak for the majority.
Yeah, I want you to speak for yourself. Sorry.
Well, for myself, I will find it difficult to subscribe to an arrangement where a public official is acquiring public property. But as I said, I think the principle, the overarching fundamental principle is a principle of conflict of interest. And the nuances will be broader than we probably can exhaust through this conversation. Because first of all, you will define who a public officer is. Second of all, you now have to have a conversation about the general contours of it. I mean, what are the circumstances under which this should be permissible or not permissible? But the general principle, in general terms, that public officials should not acquire public property. That one is something that I will not quarrel with. I will not have a difficulty with at all. Because public service is exactly what it should be, public service. You come into public life, you come into public life to serve. If you want to make money and acquire property, you go into private sector and make money and then acquire as many properties as you wish. And that nobody will have a problem with. Right. I don't have any difficulty with that kind of arrangement. But I'm saying the intricacies of it will have to be dealt with in Parliament if such a bill ever were to be presented to Parliament. Yeah.
Right. So you have given the facts that look quite incontrovertible in your 11-page statement of the 16th of July. The sale of the Parks and Gardens land in Wa and Cantonment, the sale of the E.B. Du Bois, the purported sale of the E.B. Du Bois Center, which you have indicated has not happened, the Judicial Service land, then the Prison Service land at Roman Ridge. In summary, the Parks and Gardens land in Cantonment, you have shown the lease started in 2012 and eventually was granted in 2016, not under Akufo-Addo's regime. Prison Service land at Roman Ridge, the seal or lease of the land was done in 2005 and not under Akufo-Addo's regime. Parks and Gardens land in Wa, the lease for commercial development purposes, of course, done under your government, but you justify that it's for a good purpose, and there's a filling station serving the needs of the people. The E.B. Du Bois Center, you say that it's not being sold or leased to any private entity, and you show your evidence to that effect. And finally, the Judicial Service land, you say the lease started in 2014 and effected in 2015, clearly not under the MPP regime. That's where the debate ends.
It shouldn't end there. I responded to specific allegations, and my attitude when it comes to these matters is when they are raised, you assemble the facts. And when you assemble the facts, you put the facts out. And so that is just what we did. I mean, I didn't intend to embarrass anybody or embarrass any government or point fingers at any government. My point was that allegations were made that these parcels of land had been sold by the Akufo-Addo administration, and they were evidence of, those are evidence of state capture. I mean, such an allegation should worry me, because I will imagine that the measures that we put in place to protect and ensure the effective utilization and management of our public land for the benefit of the Ghanaian people, who are the true owners of these lands, should not lend itself to this kind of situation. And so I call for the records and I call for the facts. And those are the facts we put out there. I don't want to belabor the point. But there are three fundamental points I want to make in relation to this discussion. The first one is that this heightened interest scrutiny is welcomed. I welcome it. I've said this since I became Minister for Lands and Natural Resources, that the only way we can effectively manage the lands and natural resources of our country for the good of the Ghanaian people is if all of us show interest. The legislature, the judiciary, the media, like you are doing, civil society, individuals, and so on and so forth. And so what the Honorable Ablakwa is taking up, or what is being discussed, I welcome it fully. So that's the first point. The second point is that we lose the benefit of the discussion if we situate it in a narrow, self-serving political context. Something we will lose it. It will just be an exercise in futility. It will not be productive. If we begin to say that Akufo-Addo government sold this and sold that, and therefore the Akufo-Addo government is engaged in state capture.
We have been doing that for over a decade or 2 decades now. I'm not sure it's been of any benefit.
Yes, it will not help us, because that's how I sit here. Something. I have a litany of land sales in Cantonment, in Ridge, in Roman Ridge, in Airport, in Labone, the primest of places in Accra, which were sold under President Mahama's administration. Some were sold under President Kufuor, some were sold under President Mills, some were sold under President Ronnie. So if we are going to now begin to generate...
And some were also sold under President Akufo-Addo?
Yes, exactly. I'm not going to deny that. I'm going to get to the third point, which will probably answer that question. So that if we get into that kind of finger pointing, we will lose the essence of the discussion. And if you allow me, we are at the cabinet retreat at Petuasi. This subject is a matter that has been discussed in about 3 previous cabinet meetings, and we took a great deal of time, I think, on Thursday at the cabinet meeting to exhaust a subject which is a linkage of this kind of discussion. And I'll give you a little bit insight into it. I mean, I'm getting distracted in terms of how I wanted to approach this discussion. But let me just tell you, you see, you have a situation where, for example, public institutions generally, and then if you want public universities in particular, construe lands which have been, public lands which have been granted to them as lands which belongs to those institutions, something. And they deal in them and they leverage them with third parties in a way that they pleases, in a way that pleases them. And so I don't want to mention the name of any institution, but you have institution A, who has been given, say, public lands of 50 acres to be used to attain the purposes for which the institution is established. The institution then goes, for example, into a public-private partnership arrangement with a private sector third party, and grants, say, 30 or 40 acres of the land to the private parties, private sector party, without recourse to government, without recourse to the land commission, without recourse to the ministry, without recourse to the government. And then they have this thing they call sharing of bungalows or sharing of infrastructure that will be developed on that property. No value for money. It doesn't really go to the core mandate of the institution. It doesn't serve the objectives or the objects for which the institution was established. And then the question then arises, that those lands, do they constitute public lands or not? And show that institution seek the consent of government before they are able to go into this kind of arrangement. All of these matters have been resolved, and I'm coming to issue a statement to that effect, a public statement, and we're coming to put rules to regulate that. That is a whole area of abuse across the public sector, across the public service of our country, and it's been so for years.
I thought you had resolved that. I thought you had resolved that by insisting that all such transactions involving public lands must get your certification, your approval. Otherwise, they will be deemed as void.
Yes, you are right in raising that point. It is resolved to a lesser extent. It is resolved where the land is still vested in the Lands Commission. That's number one. It is resolved where the land is being granted to the public institution, and the public institution is not construing the land as its property, and therefore does not fall within the four corners of public land as defined by the Constitution. And so the Attorney General had to come up with an opinion to, first of all, define what constitutes public land. So I'll give you an example. So you have the colonial government, which acquired large portions of land for public institutions. Here, maybe I should mention one or two, because those are the obvious ones. Ghana Armed Forces, public universities, some public institutions, had large parcels of land. And the colonial government, the Nkrumah government in particular, then grant leases to these institutions. Okay. Then the state then has reversionary interest. The question which arose, are these public lands or not? And if they are public land, are these institutions allowed to deal in them as they please, or without recourse to government, and so on and so forth? So these are the matters that we get.
But clearly on that issue, why should there be a difficulty? Because all these departments, agencies, and so on, they are under the control of the executive. So it is your edict, it is your fatwa that they will follow. That is what I'm saying. That is what I'm saying, that it has been resolved. And I'm telling you that the public institutions don't take the view that you're taking. They mount very, if you want, seemingly strong legal argument to come to the conclusion, in their view, that these do not constitute public. And something that is why actually even the New Lands Act, Act 1036, specifically Section 235, has prohibited the grant of public lands to public institutions through leaseholds or freeholds, and has actually gone as far as saying that you can only give certificate of use. You give them a certificate which will give them the right to use the land, but you cannot grant a lease or cannot grant a freehold. Parliament, in its wisdom, in enacting the New Lands Act, sought to cure this mischief moving forward. But I'm talking about public institutions who already have leases granted to them. So what is the point I'm making? The point I'm making is that it's a bigger conversation, it's a broader conversation. And the moment we narrow it down to partisan discourse, these people sold this and that, those people sold that land, we will lose the essence of the conversation. I welcome the conversation. That's right.
And I said it on your platform that we're going to have a national land symposium, which is being planned for sometime in August, where we are bringing all stakeholders for us to have this conversation. But I welcome the conversation.
Right. Nonetheless, let's get to the rebuttals to your responses and explanations. We are told that the Minister for Local Government and Rural Development, Martin J. Mensah-Kosa, answering a question in Parliament posed by Okudzeto-Ablakwa on July 4, 2024, gave a position different to yours on at least two of the instances in respect of the Wa Parks and Gardens land. He was of the view that he was going to take active steps to reclaim the land and demolish what he called the illegal fuel filling station constructed on that land. But your communication said that was a good use to the land. That was a proper, as it were, disposition of the land. What do you say to that?
Well, the specific response to that is, I would rather that I don't even get into this this person said, that person said that. But anyway, let me give you a response. Something, you're a lawyer, I'm a lawyer. I deal with records of land, okay? So if you take a government bungalow, for example, the government bungalow is managed by the Ministry of Works and Housing. It's not managed by me. I manage, when I say me, I mean the Ministry of Lands and Lands Commission. We deal with the lease. If the Ministry of Works and Housing wants to say redevelop the bungalow, they will just knock on our doors and do the needful in terms of leaseholds and so on and so forth, and then it will be done. The management of the bungalow is very much within the remit of the Ministry of Works and Housing. The Ministry of Local Government deals with planning. LUSPA, Land Use and Spatial Planning Authority, sits under the Ministry of Local Government. So if land is granted to an individual, and the individual uses the land in a manner which does not conform to the planning of that particular jurisdiction or that particular enclave, the Ministry of Local Government is very capable of invoking its bylaws and laws and so on and so on. So there is no contradiction whatsoever. I just deal with records of land. The question was posed. This particular land was sold. It's evidence of state capture. I said, give me the records which speaks to the sale or otherwise of the land. The records have been given and it's put it out. So far as I'm concerned, by operation of law, a sale is concluded when a lease is granted. So I deal with lease, and that is why I put it out. The land was sold in 2019. On the file, that's the justification that was given for the sale of the land.
The expectation then will be that you correct the minister, and on questions or in issues of law, legal matters, if it were a court and so on, your testimony or what you say will be preferred on land over what that minister will say. But it is not healthy that you are saying something different, he's saying something else. When it comes to the cantonment's land, he actually insisted that that land was firmly under the control of government and that he was going to take steps to remove the containers of the, is it Danaik, the company, real estate company on it. He actually moved to do so.
No, we are not saying two different things at all, Samson. I want to repeat. The Lands Commission and the Ministry of Land deals with records relating to land. The use of the land, the development of the land, whether the local, I mean, when you have a lease, even as a private person, if you buy land today, it doesn't mean that you can use the land for whatever purposes you choose. You will go to the local assembly, you go to the Ministry of Local Government for permits, for that, before you can develop the land. So if I say that the land was sold in 2016, that is a statement of fact. That's the fact. The fact and garden was sold in 2016, I think 29/2016. That is where the lease was granted. For purposes of sale, that is absolutely unquestionable. That's the record. The Minister of Local Government says they will not allow to develop land. They will not allow to contain on it, clear the containers. That doesn't contract the fact that the land is very much was complete. We deal with records of that. I was answering the question of the state, and I did answer that. What the Ministry of Local Government deals with and what he's dealing with, that is within his mandate in terms of proper planning, proper use of land, and so on and so forth. It doesn't contradict what I put out at all. It's not in any measure.
But we can say safely that you acknowledge that this problem is widespread, it is very bad, and that is why we understood, as I think some time ago confirmed by Kwame Jan, who has been consultant to your ministry, that you had to employ the services of someone, this man named Jato, who was going around making sure that state lands are protected. Is that correct?
Look, Samson, I mean, I'll be the first person to admit that our land administration, we still have a lot of work to do. We have a lot of improvements to make when it comes to the administration of public land and land generally in our country. It's a systemic problem, and it's not a problem which is created by this current government. It's a problem that the current government, on the contrary, is resolving. And in all humility and modesty, I feel very proud of the work that we have done at the Ministry of Lands and Natural Resources, the Lands Commission. And I challenge anybody to go to Lands Commission. I'm not saying Lands Commission is sacrosanct or that you find no fault with the Lands Commission or even the ministry. But by and large, sufficiently reasonable measures have been put in place to try and protect the public lands of our country.
Right. So how well has this private entity done in helping you to protect state lands?
This private entity was contracted as far back as 2012. The private entity, when I became minister, I took the position that the private entity should not work in isolation. So I put together what we term the Public Lands Protection Unit of the ministry, headed by the deputy minister. And the private entity was a member of that committee, so that the work that the private entity is involved in can be properly monitored, supervised, and regulated. And that is what has happened since I've been minister. But again, a question was posed about this arrangement in Parliament. I got the records and I put it before Parliament. The person, Anyok Holding Services or so, it was they were contracted as far back as 2012, and I brought the contract. I finished the Parliament with the contract. But really, I mean, the point I'm making, but there's also another point which has been made, Samson. It's not all public lands which are utilized or which are leveraged to private capital, which is in and by itself wrong. Much of Accra, Central Accra, and some of most places you see now, and the parts of the government and so on and so forth, are public lands, and which you examine, you will come to a objective conclusion that serve the country well. And several parcels of public land which are put out, which are deployed private sector participation, which is help the country. And so, when the discussion is, it's not all public land which are sold or leased, which in and by themselves are bad. I know the judiciary, for example, have done several arrangements where judges have gotten a lot of bungalows in the use of land which had bungalows, say 4 or 5 acres, and the lands were not being utilized optimally. But so in cases where the system has been abused, we deal with it. And more importantly, is to put in place institutional reforms, institutional framework to prevent the abuse. And when the abuse happens, they are flagged immediately.
My last question will be on the Bulgarian embassy issue, but raising the issue about a private person protecting these lands, something just came up and I need you to clarify for us that this private entity protects lands belonging to the police, the military, and this private person does what he does with a network that includes his own judges. Is that what it is?
Really? I don't know about this. That would be scandalous. I don't know about that.
Okay. Now, the Bulgarian embassy, your response have come, and Okujeto has a question that he has asked about, and your response appears to admit eventually that this is what happens, that it was owned by an individual, and then this individual leases it, or as it were, outright say whatever it is, to the Bulgarian embassy. Then, upon his death, his, executors of his will or whoever they are, now come in and disturbs the Bulgarian embassy. Then subsequently, we are informed of this land having been given to somebody who belongs to your government or party.
Is the Honorable Kujito in the studio?
Yes, it's right here.
Oh, okay. Hello. I don't know. I'm not too sure what the issue is with the Bulgarian embassy, which is still agitating the mind of the Honorable Kujito Ablakwa. Because I think this matter is dealt with very, very properly and dealt with squarely. First of all, Samson, if this controversy, or this dispute had arisen between two private entities or two private individuals, the government of Ghana would not have stepped in any form or shape whatsoever. This land was public land. The land was sold or leased out as far back as 1974. So you replace the Bulgarian embassy with Mr. Samson Ayine. That will mean government of Ghana will not even be interested in it in the first place. The matter would have been dealt with as it was being dealt with in the courts, in the law court. This matter has been a subject matter of multiple seats in the law courts. Government of Ghana came in simply because it's a diplomatic mission, the Bulgarian embassy. That is the only reason why the government of Ghana, through the Ministry of Lands and Natural Resources and the Ministry of Foreign Affairs, have had to come in. And I think you've given the facts correctly. This is a dispute between an individual and the Bulgarian embassy. The Bulgarian embassy claims ownership of the land. The individual claims ownership of the land through inheritance, as you rightly pointed out. Even before the matter will be dealt with in the law court, the person proceeds to demolish the building of the Bulgarian embassy, purported building of the Bulgarian embassy, because this is still
Press one to a court order.
Press one to a court order, correct. But it's a diplomatic mission, so government has to step in. And so I then appointed a sole inquirer, Justice Oforiatta. Justice Oforiatta goes into the matter and brings up a report. Okay, I had to call the parties and ask the parties to submit to my mediation, the mediation of my good office, because they are not obliged to. The private individual could have taken the view that, Mr. Minister, you don't have jurisdiction on this matter. I want to press my case in court. There's very little I could do about it. But I used my good offices to bring them out to the negotiating table. And the question then arose as to what is the value that should be put to the damage to the Bulgarian embassy building. I said, let me put together a technical mediating committee. And we did so, representing a representative from Foreign Affairs, representative from the Ministry of Land, representative from the Lands Commission, the Bulgarian embassy, and a private entity. They sat down and they took the view that to be able to ascertain the value of the building, the statutory body responsible for that is the Land Valuation Board. So let's have the Land Valuation Unit of the Lands Commission do the valuation. The Land Valuation Unit does the valuation and comes up with 5.3 million Ghana cedis. Okay, something. Now, we say that the private developer should pay the Bulgarian embassy because they want to have access to the land. They demolish the building. That cannot be the liability of government. And there's never been any confusion or misunderstanding as to who should be liable or who should be responsible. The parties are still in talks with the government mediating team, to find a final resolution of this matter through the payment of this money. Then I think the Honorable Okujetu put out a statement who suggested that government is mulcted in damages or liabilities of 5.3 million Ghana. I said, no, government cannot, by any stretch of imagination, be responsible for even a penny of this particular litigation. Government cannot be, and government is not. And that is the clarification that I put out.
All right.
So in this matter, what will be with the greatest of respect, perturbation of anybody? I mean, government rather is gone at the great length to try and resolve a matter which involves a diplomatic mission.
The Dr. Yao Edu-Amponsah has no connections to your party or government and did not use the power of state somewhat covertly or overtly to acquire this property. That's the clarification you are making.
Acquire the property in 1974?
No. I'm not talking about the one who acquired it in 1974.
Yeah, you state power to do what? I want to understand. I don't even know the people involved. I don't know them. I don't know their
acquired 11 December 2018
or their ethnic background or whatever. I don't know.
No. So what I'm actually referring to now as a confirmation of he being the present owner is from paragraph 5 of your press release dated 18th July. So
if you could please kindly read it to me.
Yes, the sole inquiry also made a finding of fact that Mr. Lengten leased the property to the Bulgarian embassy by a private contract. Following the death of Mr. Lengten, however, the executor of his will, Mr. Jojo Hagan, caused the property on the land to be demolished, pursuant to a court order, before assigning the land to one Dr. Yao Edu-Amponsah. And Dr. Yao Edu-Amponsah, as we understand...
Ampoma.
Okay. Dr. Yao Ampoma. And we understand Dr. Yao Edu-Ampoma got this property in 2018.
Yeah, but the issue we are dealing with is the demolition. That's exactly what we are dealing with. If the Bulgarian embassy building had not been demolished, there would not have been an issue. It would have been a pure civil matter in the law court, which the law court will determine something. I mean, you're a senior lawyer, so I mean, the ownership of land is not determined by the Minister for Lands if the parties disagree. It will be determined by a court of competent jurisdiction. And as I said, they were in court.
Right.
There have been multiple suits in court. Hold on, just a minute. And then we are told that somebody used government power or connections to government to demolish the building. You just read the statement which said that the demolition was done pursuant to a court order. So how does that become the responsibility of the government?
All right.
When it was done pursuant to a court order.
Thank you very much, Samuel Abu Jinapor, MP Damongo and Minister Lands and Natural Resources.